So, Constitution of Article 1, first and foremost. What other powers in the other articles? What about the enforcement powers since the Civil War? When you're ready, you may begin.
In John Locke's second treatise on government, he argued, freedom of men under government is to have a standing rule to live by, common to everyone of that society, and made by the legislative power vested in it. The founders, influenced by John Locke's social contrast philosophy, thought that the legislative power of government was its most important role.
During salutary neglect, the colonial legislature successfully experimented with self-government, encouraging the founders to apply it on a national scale. The first attempt, under the Articles of Confederation, resulted in a weak and ineffective Congress. The need for a stronger national legislature was clear. However, they were hesitant to grant it a majority of the authority, so they addressed the powers and limitations of Congress first and in greater detail when drafting the Constitution.
Article 1, Section 8 specifies what Congress has the ability to do. However, unlike the British Parliament, Congress's powers are limited by Article 1, Section 9, which includes broad restrictions on bills of attainder, ex post facto laws, and more. The founders also wanted to avoid the British Parliament's universal and aristocratic representation. Thus, they created the House of Representatives and the Senate to represent both the people and the states.
In addition to the power granted to Congress in Article 1, several other articles address legislative power. Article 2, Section 2, Clause 2 states that the Senate has final approval over all executive and judicial appointments. Ronald Reagan's appointment of Robert Bork was the last time Congress rejected a Supreme Court nomination. Article 2, Section 4 allows Congress to impeach any member of the federal government, like in the 2011 case of Thomas Porteous, a Louisiana federal judge. Article 3, Section 1 gives Congress the power to ordain and establish courts, which they've used to control the number of Supreme Court justices and create the federal court system.
Article 4, Section 3, Clause 2 gives Congress the power to produce rules and regulations for territories under United States control and admit new states. For example, Puerto Rico's territorial constitution had to be approved by Congress in 1952, and they are subject to the United States federal law. Congress also has the ability to propose amendments to the Constitution. Since the Civil War, Congress has adopted a series of amendments with provisions that have expanded their power.
Most post-war amendments have a clause that allows Congress to pass legislation to enforce its provisions. The 13th, 14th, 15th, 19th, 23rd, 24th, and 26th Amendments all grant Congress this power. Many important pieces of legislation are based off these clauses. The Civil Rights Act of 1866 and 1871 prohibit all racial discrimination and give the government tools to enforce both the 13th and 14th Amendments. In fact, the Civil Rights Act of 1781 was formerly titled An Act to Enforce the Provisions of the 14th Amendment. The Voting Rights Act of 1965 outlawed the use of literacy tests and other means to prohibit individuals from voting based on race, in accordance with the 14th and 15th Amendments. The Supreme Court took on this enforcement provision in the 1996 case Katzenbach v. Morgan, in which the Voting Rights Act was upheld as constitutionally protected enforcement.
The Pregnancy Discrimination Act of 1978, which prevents business owners from firing employees because they are pregnant, is justified under the 14th Amendment's Equal Protection Clause. The Equal Employment Opportunity Commission is currently suing 4 separate companies on behalf of pregnant women who are discriminated against. These enforcement provisions are not without limits. In the 1997 City of Bourne v. Flores, the Supreme Court ruled that Congress could not use its enforcement powers to pass laws that interfered with enumerated constitutional rights, striking down the Freedom Restoration Act.
The founders wanted Congress to be the most important and effective branch of government, but modern Americans are hardly satisfied. A 2012 Rasmussen poll revealed 8% of the country felt Congress was doing a good job. To compare, 5% of the country has a positive opinion of Fidel Castro. That's within the margin of error.
Thank you.
Good feedback.
Good job with eye contact, guys.
It wasn't highlighted, see?
And sometimes, like, you guys just, the way I do it is, like, I pick a word, like, 2 or 3 words before, like, I have to talk, and I, like, memorize it, like, normally something unique that, like, isn't heard often, like, not the, right? You don't want to pick that. And then, like, as soon as I hear it, then that's when I know I, like, look down and start getting ready to read. Yeah, so that's how I do it. But otherwise, good job.
Okay, I thought, I think you two were trying, like, to make that eye contact, and it was great. Just try to make, when you do make eye contact, a little bit longer. So there's, like, that pause where we connect, and then you look down again instead of, like, fewer moments of good eye contact as opposed to, like, more moments of, like, brief eye contact. But
Quality, not quantity.
yes, exactly. I liked your tone, by the way.
Thank you.
I really liked the ending with Castro. That was pretty awesome. I feel like the first two bullets sort of ran together, and then suddenly you started really answering the second bullet, so I got a little bit confused there. So maybe for that first bullet, why the powers are addressed
What are
first.
the first and second bullet?
The first one is why are the powers addressed first and in greater detail, and then the second is in addition to those powers, what other provisions? So it seems like those sort of almost ran together. Just a
I
heads
think
up.
Jack, you read that part. I think you say it specifically, don't you?
Yeah. Then he starts really answering the second bullet.
They don't go between it before that.
I
It's
feel like
all-
we have to give the background to why,
Yeah.
basically. That's what we do in the beginning, and then
Are you,
state it.
well, because we talk about like the history, like Scyther neglect and everything, and then we mention like the British Parliament and like Article 1, Section 9, like is that what you're talking about?
Yeah, like around that area, it seems like you guys could have a little bit more of the background and a little bit, like, because suddenly it seems as though it's answering both. It really does, and then
Article
Jack
1
really
is
answers
the-
the second one.
No, I think
But it could just be an opinion.
it's. I think because I know what you're saying with it. They're doing the background of why powers are there, and then they're
Yeah.
specific to it. So I think while they're not answering specifically, they are. I think they're doing exactly what they're doing, and then answer it because they're trying to lay down why in greater detail than the others.
Okay.
Okay.
Okay. I had another point. No, it's okay. How have the enforcement provisions increased congressional power? You guys hit that really well, only you don't, you like mention it and you say like, now there are acts, but you don't ever say like, as opposed to before when they couldn't do something. And I feel like if you said as opposed, you could use a previous event almost. And like stick in a little historical example, like before they could only do this and now they can do this. Stuff like that.
That'd be good.
Yeah,
Yeah.
I like that.
I like that too.
What time?
were we at?
You guys were 3:48,
So we got enough time.
but
Whoa, that was the exact time before.
we. I felt like Jack didn't breathe at all. You gotta enunciate,
Talked a
Jack.
little fast. I just
Yeah,
wanted to make that
Chase,
comment.
me
Yeah,
too.
but,
I say Jack and you guys need to breathe a little bit.
like not like
Yeah.
You're like your sentences start doing this.
for the lead.
I figured they'd chill with more reading.
I like to
And
pinch
I
my fingers
smile.
like this because it makes me slow down.
All
I
right.
feel like I'm talking like Obama.
Oh, yeah, don't forget to smile, guys.
I don't
You-
smile.
Smile.
I
I don't
stare
understand
Just,
that.
but don't be like this, like it's the most miserable thing in the world.
We should
You're
all-
smiling right now. Look at
I
that.
always
Because you're-
Let's all smile and
Why-
give us
yeah, that's
some
what
It's
encouragement.
just weird, you're like
Right,
writing
so-
smile.
You wanna know what I do? I just like think of a word and go, ha, that's funny. And then see, just think of the thing that and we'll smile every time.
You were cracking up because Colonel was talking.
He's so cute.
I'm seriously
Presidential pen.
offended on so many
She
levels.
doesn't have a problem.
Presidential powers expanded since the ratification. Emergency media and wars contributed to expansion. How have other branches of government responded to this expansion? When you're ready, you may begin.
In a speech to the Senate in 1834, President Andrew Jackson stated, "It was settled by the Constitution, the laws, and the whole practice of government that the entire executive power is vested in the President of the United States." By the time Jackson gave this speech, the founders' view of presidency as an energetic but limited institution was becoming irrelevant. During Thomas Jefferson's 1800 campaign, his main focus was to uphold the ideas of the founders. But even the noble Jefferson realized the limitations of the Constitution's vague enumerated powers once in office when he purchased Louisiana and enforced the embargo of 1807.
By 1834, Andrew Jackson had become a key player in the expanded executive. He used his veto authority more than all of his predecessors combined. He also refused to support the Second Bank of the United States, impounding federal funds using his power as chief executive. When the Supreme Court ruled against the state of Georgia in the 1832 case Worcester v. Georgia, Jackson is famously attributed to have said, "John Marshall has made his decision, now let him enforce it." He proceeded with his policy anyway, eventually pushing Congress to pass the Indian Removal Act, unfortunately resulting in the Trail of Tears.
Abraham Lincoln was checked by the judicial branch during the Civil War in the Supreme Court case Ex parte Milligan, after he unilaterally forced martial law in Maryland. Federalist 69 made it clear that the president would not be able to raise and regulate fleets and armies by his own authority. However, Lincoln independently raised a blockade against southern ports, defying the intentions of the framers.
During World War II, Franklin Roosevelt bypassed his constitutional obligation in Article 2, Section 2, Clause 2, when he made executive agreements with Joseph Stalin and Winston Churchill without the consent of the Senate. Due to the tensions of the Cold War and the increased military presence of communist powers within Vietnam, Lyndon B. Johnson continued the expansion of power when Congress surrendered its authority with the Gulf of Tonkin Resolution. Johnson was able to pursue and escalate conflict in Vietnam without a declaration of war.
During the Great Depression, presidential power expanded yet again with Franklin Roosevelt's use of executive orders. In his second day of office, FDR issued an executive order closing the national banks. He established many New Deal programs like the Works Administration, Progress Administration, without the approval of Congress. Following 9/11, Americans looked to the president to react forcefully. George W. Bush immediately grounded air traffic to raise the army and shut down financial markets. 3 months later, he effectively declared war on Afghanistan with an executive order.
Time Magazine's editor-in-chief, Fareed Zakaria, noted the media creates a perception that the president holds sovereignty along with Congress, though the framers envisioned Congress holding all the power. FDR exploited this when he attempted to appoint 6 new justices to the Supreme Court. Although met with congressional disapproval, he tried to win the favor of the public with his fireside chats. Today, news networks such as Fox News and MSNBC further the perception of presidential power. Critics of the Affordable Care Act, also known as Obamacare, blame it on the president and ignore the fact that Congress created, passed, and funded it.
During the Watergate scandal, the Supreme Court attempted to check Nixon by revoking most of his executive privileges. However, as Justice Jackson had earlier noted in Youngstown Sheet and Tube Company v. Sawyer, I have no illusion that any decision by this court can keep power in the hands of Congress. Only Congress itself can prevent power from slipping through its fingers. For Nixon, Congress reacted by initiating the process of impeachment. Clearly throughout history, Congress has rarely acted adequately to address the rise of the presidency. A good example of this is the Wars Power Resolution of 1973. This was Congress's first attempt to check the uses of power after the Vietnam War. However, it was a non-binding resolution and has never been invoked. One of the most effective checks that Congress has is the power to control the funds the president needs to enforce his laws. Another powerful check is to not pass the president's legislation. The do-nothing Congress under Truman passed nearly 5 times as many bills as our current Congress.
In Federalist 70, Hamilton noted, "Energy in the executive is a leading character in the definition of good government. This energy has grown beyond even Hamilton's expectations. With more conflicts, emergencies, and media coverage, presidents have pushed this to the extreme and advanced the limits of their power."
Can I go first? I forget. Okay, thank you. Sorry. So I think I might have zoned out, or no. Okay, I have real comments. But again, I missed the emphasis on emergencies for
Yeah,
the
FDR.
second one.
FDR.
Yeah.
Do you guys
Great
say the word
Depression and
emergency?
9/11.
Yeah, the war emergencies power was like state.
I know. Did you guys say the word
No.
emergency?
No.
No, we
You
didn't.
might want to. Just a heads up. I know it sounds really trivial, but
we
it
had
helps.
that in there previously.
Yeah, I
Just-
think it was in the
Just a heads up.
cut out in the beginning. That's all.
Which didn't actually cut time in the end.
But I did like it a lot. You guys don't really go into, do you think they have done so adequately? You mention it in like one little line, but other than that, you don't really say if they have, and you don't necessarily go into the judicial branch. You mentioned that they say they don't have the power to fix it, but I'm pretty sure there have been previous cases where they have actually done something that is a check.
Yeah.
We
So-
have,
We
throughout the
know.
whole paper, we have judicial branch.
Worcester v.
As
Georgia,
checks.
Ex parte Milligan,
Yeah, Worcester, Milligan,
See, everyone
Youngstown.
Youngstown Sheet and Tube Co.
See, this is the problem we have, because
Yeah.
everyone
doesn't recognize
everyone
it,
sees
but
that issue where they're like,
It's-
oh, it's not defined enough. So do you think it should be like a
Yeah,
separate?
it's probably like our first one, how we answer it kind of like
Yeah.
throughout.
You think it needs to be like
Judges
distinct?
are probably simple
But I
minded.
feel like
Listening to stuff is sometimes hard.
do
You
you
might
think it
want
would feel awkward, like, back to this, like, in that, the judicial
I
branch?
say, what if you just
tried to
group
check?
it, like all of the, like answer the questions in order.
or maybe
Yeah,
even
But then
like,
that's where the court cases.
The judicial reviews go with every, like,
Different
amendment we
questions.
say,
Maybe
like,
So-
wars.
like grab out a couple of those, like maybe 2 if you have more, like if you have like 4 of them, grab out 2 and then stick those in your other paragraph, and then reference the other ones, like blank and blank, blankety did this, like that or something.
Or
However, no, you know what I think you do is that that part where you have Lincoln, because that's the first time where you guys use it, right? In the ex parte.
Abraham Lincoln was checked by the judicial branch during the Civil War.
I would put something in there, just some sort of clause that, while I don't know.
What if we took that Lincoln part and put it in the like Congress?
what if you guys like let off like it kind of established that judicial review is like a reoccurring theme for checking back presidential power, and then like just continuously like say like another example of judicial review, right? Like and say so like.
That could work.
But that's not. But that's not judicial review.
Well, not just like
The court
Almost-
checking.
The court checking the
almost
president.
answer
So-
it out
so-
of order.
yeah, so like
or like
at the top
split.
established that like this is like one of the best ways that you're limiting presidential power, and then like throughout the rest of your case when you sprinkle those examples in like you guys do, then sort of like tie it back into that header or whatever, where like
I got a
this
really good
is
idea.
another example of how courts check the presidency.
Or do you like, that way you could also bring in, do you think they've done so adequately? Say something like, the other branches haven't really done so adequately, but the court has,
You say
yada,
that.
yada, 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 bring in some stuff, and then say, as previously stated, the
No,
court has
no,
done a
that's
good
not
job
good
of
either.
checking,
No.
and Congress not, something like that. I don't know.
Oh, so like.
Like
just
rearrange,
parallel
like
that sentence
mention, like,
with the.
yeah, like mention first, like, they haven't done a good job, but the court
So, like,
has,
restate it,
reoccurring, blah,
Like
blah, blah,
state
blah,
it
blah.
twice, kind of,
Yeah.
so it's like for sure in there if they.
As stated, courts have done this, but
Okay.
some, maybe, I don't know.
Yeah, I think that's the way you'd have to do it.
Good idea.
As mentioned through.
Or like, as mentioned.
I don't, because I hate
before,
referring
in-
back and making them sound stupid, but
What if we did it? I think she means like in
I
the
think it's gonna have to be
beginning, kind of. I don't know.
This is the
It's
struggle.
gonna take some
This is
looking
hard.
Just
around. We have,
rearranging that
Why
part.
don't you write a book
Issues.
called Mein Kampf about it?
I think I will. I think I will.
Eye contact anyways.
What was the time on that?
418.
Oh my god.
That's our
Say it
exact
every
time.
time. It's 3 times in a row. 42.
Ah.
We kept
So-
4 seconds with all those sentences.
I keep getting tongue tied.
Eye
And yes,
contact
you
was good.
It's only
but-
with you, Clark.
It's like stone faces, and then like we get to Sydney over here, and she's like a little ray of sunshine. And we have you guys who look like, oh my god, like I have to be here. And she's like sitting there laughing at random
you,
words.
Lisa.
Like what? Like you guys just need to smile more.
Okay.
Like
Yeah,
not
yeah.
creepy, but she like makes it look natural. Like take advice from her. Like take some like whatever she's on. Get some of that before we get going. But, no,
she's
it's
always
good.
so happy.
Yeah.
Alright.
Sarah, you looked
Alright.
much more comfortable for
Let's
the
go.
time. I thought it was good. You looked happy. And Jack, wait, real quick. I think you need to relax a little more and enunciate.
You were better than the first one,
Yeah,
but you're.
I saw improvement though. And you all smiled
You tap
at
your
one
foot,
point at
too.
least, so.
I noticed that. I tap my foot too, but you
We're gonna have
tap your
skirts, so don't worry about your feet.
foot. Okay.
Really?
We'll have a table skirt.
Can I do that?
Sweet.
I just like tap dance.
Yeah, people would think you're like.
All right.
I probably won't hear you. Wait, I have a question.
You know.
Do you speak in
Don't do
microphones?
that.
No, there won't be a microphone.
Okay.
Is it
Especially if you're doing
It's a
that
classroom.
cross
It's a classroom.
Your hands are
Oh,
down
It's gonna be like the
so-
classroom we were in,
Oh, cool.
so a
Alright.
little
So it's
bigger.
gonna be like small.
Federalism.
No, it'll be one of we'll have one of the bigger
Oh, it's
classrooms.
gonna be like those huge auditorium kind of
Yeah.
things?
Oh.
No, it'll be that
do
big.
we have to practice speaking loudly?
Yes. You guys are fine.
Okay.
All right.
Full score.
Federalism. Mike, shut up.
Jack,
Just
shut
a
up.
change of pace.
Federalism. Why they create it? How does it limit powers of both national government and states? What opportunities give citizens to participate? Go.
In his 1981 inaugural address, Ronald Reagan stated, "All of us need to be reminded that the federal government did not create the states. The states created the federal government. The dichotomy between the national and state governments is the defining feature of the American system of government. Historical failures of both the unitary and confederate system encouraged the creation of federalism."
Following the French and Indian War, Great Britain was left with a staggering debt. As the economy stagnated, they were forced to turn to the colonies for money. Revenue-raising measures, like the Sugar Act of 1764 and the Stamp Act of 1765, enraged the colonists. These taxes, along with the perceived lack of representation, pushed the colonies to revolution. When they were finally free from the restraint of the British central government, the colonies joined together in a confederation. However, this proved to be a remarkable failure.
The Articles of Confederation left no way for Congress to enforce laws, make foreign policy decisions, create a standing national army, or provide a source of revenue. This limited power meant the national government could not even control a simple protest. Shays' Rebellion was a protest caused by the post-war economic crisis. It was unable to be quickly stopped because they could not assemble the state's armies and no national army existed.
After experiencing the failures of both the Unitary and Confederation, the founders recognized the need for change. They created a system of government known as federalism, which is a division of power between the central government and state or local governments. That combines the aspects of both Unitary and Confederation systems. Wanting certain powers to remain with the national governments and certain powers to remain with the state governments, limits were placed on both in the Constitution and in the Bill of Rights.
Alexander Hamilton once explained, "It's not tyranny we desire, it's a just, limited federal government." The framers of the Constitution shared Hamilton's desires and wanted to preserve state power. The 10th Amendment is the clearest example of this. It ensures that the Constitution only defines the limits on states, not their powers. Article 1, Section 10 enumerates some of these limits. States are prohibited from coining money, entering war, and creating treaties. Article 4, Section 1 and 2 forces states to respect contracts under the full faith and credit clause. The 14th Amendment, Section 1, specifies that the state shall not make or enforce any law which would abridge the privileges or immunities of citizens. While the states seem to have many restrictions, it pales in comparison to the federal government. Article 1, Section 8 states that the national government may only take certain actions.
Unlike the states, Congress is limited to the powers given to them by the Constitution. This has allowed states to expand jurisdiction and provide more diversity of law. For example, marriage is never mentioned in the Constitution, making it a state's right. Currently only 9 states allow same-sex marriage. Only because of the system of federalism is the diversity possible. However, in the 1987 case South Dakota v. Dole, the 10th Amendment and thus the power of the states were limited. The federal government is able to place conditions on the state if it qualifies under these 4 restrictions. The condition must be unambiguous, promote the general welfare, relate to the federal interest, and conform the 10th Amendment's reservation of power to the states.
Civic participation is a basic right that can be used in one of the 87,909 governments in the United States. One of the most common forms comes by voting for representatives in these different levels. This gives the public a more personalized connection to their policymakers. The First Amendment allows people to petition and assemble. Occupy Wall Street is a protest currently going on about wealth inequality and political corruption. On November 19th, Occupy Wall Street held an event to help the less privileged communities hit by Superstorm Sandy.
Jury duty allows citizens to be part of the judicial process by utilizing the opportunity to aid governments in giving citizens a fair trial. These are just a few of the many ways for citizens to actively participate in federalism. New York Congressman Charles Rangel stated, "Full participation in government and society has been a basic right of the country, symbolizing the full citizenship and equal protection of all." Thank you.
Jack, you tried so hard to smile, and then it ended up being like,
I looked up in the middle of my... I look up, make eye contact in the middle of when I'm talking.
it's weird, but also I smile.
I look up in the middle of my part, and I see this crazy smile from you, and I can't help but start to laugh.
No, this is what it was. It was like.
Okay, stop. We're way behind, so give them a comment and let's go.
It was good. You guys did fine.
We need to go.
Yeah, I think overall, you cut it down. It's good.
Perhaps you can stick in a quote from the Articles of Confederation. That would be an idea. You don't even mention the Supremacy Clause. You mention like how federalism limits the power, and you just sort of